I agree with the chairman on the importance of all the subjects that he mentioned. I do think, however, that prison reform and sentencing reform are very intermixed and really should be considered together. I yield back.
Pursuant to notice, I now call up H.R. 3356 for purposes of markup and move that the committee report the bill favorably to the House. The clerk will report the bill.
Mr. Chairman, what number?
I'm sorry. I was given a more than complete notebook. Pursuant to notice, I now call up H.R. 1689 for purposes of markup and move that the committee report the bill favorably to the House. The clerk will report the bill.
H.R. 1689 to protect private property rights.
Without objection, the bill is considered as read and open for amendment at any time, and I'll begin by recognizing myself for an opening statement. The protection of private ownership of property is vital to individual freedom and national prosperity. It is also one of the most fundamental constitutional principles. As the founders enshrined property rights protections throughout the Constitution, including in the Fifth Amendment, which provides that private property shall not be taken for public use without just compensation, this clause created two conditions to the government taking private property. First, the subsequent use of the property must be for the use of the public. And second, that the government must pay the owner just compensation for the property. However, more than a decade ago, the Supreme Court, in a controversial 5-4 decision in Kelo versus City of New London, expanded the ability of state and local governments to exercise eminent domain powers beyond what is allowed by the text of the Constitution, by allowing government to seize property under the vague guise of economic development, even when the public use turns out to be nothing more than the generation of tax revenues by another private party after the government takes property from one private individual and gives it to another private entity. As the dissenting justices observed, by defining public use so expansively, the result of the Kelo decision is effectively to delete the words, quote, for public use, end quote, from the takings clause of the Fifth Amendment. The specter of condemnation hangs over all property. The government now has license to transfer property from those with few resources to those with more. The founders cannot have intended this perverse result. In the wake of this decision, state and local governments can use eminent domain powers to take the property of any individual for nearly any reason. Cities may now bulldoze citizens' homes, farms, churches, and small businesses to make way for shopping malls and other developments. To help prevent such abuse, using Congress's constitutional legislative powers, it's important that Congress finally passes the Private Property Rights Protection Act. I want to thank Mr. Sensenbrenner for reintroducing this legislation. He and I have worked together on this issue for many years, and I am pleased that this legislation incorporates many provisions from legislation I helped introduce in the 109th Congress, the STOP Act. Specifically, the Private Property Rights Protection Act would prohibit state and local governments from receiving federal economic development funds for 2 years when they use economic development as a justification for taking property from one person and giving it to another private entity. In addition, this legislation grants adversely affected landowners the right to use appropriate legal remedies to enforce the provisions of the bill and allows state and local governments to cure violations by giving the property back to the original owner. The bill also includes a carefully crafted definition of economic development that protects traditional uses of eminent domain, such as taking land for public uses like roads, while prohibiting abuses of the eminent domain power. No one should have to live in fear that the government could take their home, farm, or business simply to give it to a wealthier person or corporation. As the Institute for Justice's witness observed during a hearing on this bill, using eminent domain so that another richer, better connected person may live or work on the land you used to own tells Americans that their hopes, dreams, and hard work do not matter as much as money and political influence. The use of eminent domain for private development has no place in a country built on traditions of independence, hard work, and protection of property rights. This legislation has passed the House 3 times previously, either by voice vote or with the support of at least 80% of House members in an overwhelmingly bipartisan vote, only to be stalled in the Senate. But the fight for people's homes continues, as will this committee's efforts to protect federal taxpayers from any involvement in eminent domain abuse. Just a few years ago, every single Republican member voted for the very same legislation on the House floor, as did 2/3 of Democratic members. I urge all of my colleagues to join me in supporting this overwhelmingly bipartisan effort. It's now my pleasure to recognize the ranking member of the Judiciary Committee, the gentleman from New York, Mr. Nadler, for his opening statement.
Thank you, Mr. Chairman. Mr. Chairman, I question whether marking up H.R. 1689, the Private Property Rights Protection Act of 2017, is the wisest use of the committee's time. To begin with, the bill is a response to Kelo versus City of New London, a now well-established 13-year-old Supreme Court decision to which most state legislatures have already reacted by curtailing their eminent domain authority. Worse yet, this measure could potentially devastate the finances of state and local governments. It also raises federalism concerns. For these reasons, I must oppose the bill. Kelo affirmed the right of a city to use eminent domain to take and transfer property from one private party to another for the public purpose of economic development. Building on a century of precedent defining public use to include a public purpose, the court held that such a transfer satisfied the Fifth Amendment's takings clause, which provided that no person's, quote, private property shall be taken for public use without just compensation, close quote. This legislation seeks to overturn Kelo by prohibiting the use of eminent domain for the purpose of economic development through private-to-private property transfers by any state or local government that receives federal economic development funds. The bill defines economic development funds broadly to include any federal funds distributed to states or localities under laws designed to improve or increase their economies. Should a state or local government violate this prohibition, it is subject to the loss of all such funds for 2 years. The power of eminent domain is an extraordinary one and should be used with great care. Historically, there are examples of states and localities abusing the eminent domain power for purely private gain or to benefit one community at the expense of another. Eminent domain, however, is also an important tool, making possible transportation networks, irrigation projects, and other public works that support communities and are integral to their economic and social well-being. I continue to believe, as I have since 2005, when we first considered this bill, that it is the wrong approach to a very serious issue. Most importantly, this bill would cast a cloud over potential future takings and could destroy state and local governments' ability to float bonds because of the increased risks and attendant increased interest rates. The loss of all federal economic development funds is so draconian and misguided a penalty that a government that never takes a prohibited action would be financially hobbled by it. Municipal bonds could not be sold or could be sold only for very high interest rates because of the fear that the municipal government might in the future use eminent domain improperly and thereby lose all federal economic aid and with it the ability to repay the bonds. Even projects unrelated to takings could lose funding and cities could face bankruptcy simply by incorrectly guessing whether a given project would sufficiently qualify as being of public use. In addition, the bill's definitions appear to prohibit some projects that might have a genuine public purpose while allowing other uses that historically have been abused. There is no obvious rhyme or reason to such disparate treatment. For example, H.R. 1689 allows the use of eminent domain to give property to a private party, quote, such as a common carrier that makes the property available for use by the general public as of right, close quote. Does that include, for example, a stadium? A stadium is privately owned and available for use by the general public as of right. Affordable housing, such as the Hope 6 program, which uses federal money to encourage private development of mixed-income housing as a way to respond to failing public housing projects, or the Nehemiah program, a faith-based affordable housing program in Brooklyn, could never have gone forward. So under this bill, public housing completely constructed by the government is permissible, but public-private partnerships for affordable housing are not. In addition, the bill is unnecessary. Since the Kelo decision, there have been new developments that call into question whether Congress should even act at this point. In response to Kelo, more than 40 states have moved aggressively to narrow their eminent domain laws. In doing so, states have carefully considered the implications of this decision and the needs of their citizens. H.R. 1689 does not even help an aggrieved property owner or tenant because they cannot sue to stop the allegedly prohibited taking. They cannot get any damages other than the just compensation they got at the time of the taking. The bill only authorizes suit after a condemnation is proceeding when it is too late. All that injured persons can get is the psychic satisfaction that they may get from bankrupting their community. But in other words, this bill provides no remedy to the victim of the improper taking. Finally, H.R. 1689 undermines federalism and may raise constitutional concerns. Subject to the Takings Clause, local land use decisions are generally left to the judgments of state and local governments, which are in the best position to weigh local conditions and competing interests. This is the essence of federalism, and Congress should not be in the business of sitting as a national zoning board. Also, the loss of all economic funding, even for projects that may have nothing to do with takings, is so draconian that it may amount to an unconstitutional coercion of state and local governments. The bill takes a sledgehammer to what may not even be a nail. It threatens communities with bankruptcy without necessarily protecting property owners or the communities most vulnerable to abuse of the eminent domain power, all while raising potential federalism concerns. For these reasons, I urge the committee to reject this bill, and I yield back the balance of my before yielding back the balance of my time, I want to express my appreciation, as ranking member of the Committee on the Judiciary, I want to express my appreciation for Maureen Gray's work with the committee over the past 2 years, as this is her last week. Maureen came to us as a detailee, having worked for nearly 6 years as an assistant public defender in Puerto Rico. As counsel to the committee's Democrats, Maureen provided indispensable analysis and advice concerning oversight hearings and a wide range of legislation. We have appreciated and benefited from Maureen's energy, enthusiasm, and insight over the past 2 years, and wish her the best in her move to Phoenix, Arizona. With that, I yield back the balance of my time.
Thank you, Mr. Nadler, and I want to join you in expressing the committee's appreciation to Ms. Gray for her service to the...
The gentleman yield?
Certainly.
May I just add my appreciation to Maureen Gray with a caveat that we hope we will see her soon. But she has been outstanding and a real commitment to justice issues and as well to issues in particular dealing with the Criminal Justice Subcommittee. So let me wish her a farewell, but a temporary one, and much appreciation and applause for her service to the nation. I yield.
Thank you, Ms. Jackson-Lee. The chair now recognizes the gentleman from Wisconsin, the chairman of the Crime Subcommittee and the chief sponsor of this legislation, Mr. Sensenbrenner, for his opening statement.
Thank you very much, Mr. Chairman. I am pleased that the committee is considering H.R. 1689, the Private Property Rights Protection Act. This is an oldie but goodie. You know, it's been overwhelmingly passed in this committee and in the House of Representatives 3 times in the past. The Senate has failed to do the right thing, and we ought to give them a chance to recant. My bill aims to restore the property rights that the Supreme Court usurped in 2005. Our nation's founders recognized the importance of the individual right to personal property and enshrined it in the Constitution. The Fifth Amendment plainly states, "Nor shall private property be taken for public use without just compensation." However, our legal understanding of public use changed drastically by the Supreme Court when it ruled in Kelo versus the City of New London that economic development can be a public use under the Fifth Amendment's Takings Clause. In a 5-4 decision, the court held that the government could take private property from an owner, in this case Suzette Kelo, to help a corporation or a private developer, in this case Pfizer. And the now infamous Kelo decision generated a massive backlash. As former Justice O'Connor stated in her dissent, the government now has license to transfer property from those with fewer resources to those with more. The founders could not have intended this perverse result. Even 13 years after Kelo, polls show that Americans overwhelmingly oppose property being taken and transferred to another private owner, even if it is for the public economic good, read more taxes. If the Private Property Restoration Act is needed to restore these individual property rights that the Supreme Court invalidated, Although several states have passed legislation to limit their power of eminent domain, a number of state Supreme Courts have barred this practice under their state constitution, and these laws only exist to a varying degree. H.R. 1689 would prohibit state and local governments that receive federal economic development funds from using those funds as a justification for using eminent domain powers. The state and local government violates this prohibition will be ineligible to receive federal economic development funds for 2 years. This is the stick to make sure that this law works. The protection of private property rights is one of the most important freedoms guaranteed under the Bill of Rights. I am mindful of the need to end the long history of eminent domain abuse, particularly in low-income neighborhoods, which consist of predominantly minority communities. I'm also mindful of the reason we should allow the government to take lands that is deemed hazardous and constitute immediate health to public health and safety. I believe this bill accomplishes both goals. I urge my colleagues to join me in protecting private property rights for all Americans and limiting the dangerous effect of the Kelo decision, and yield back the balance of my time.
Mr. Sensenbrenner.
We'll come back to the gentleman. Mr. Cohen has stepped out, so we will go to the gentleman from Iowa, Mr. King, the chairman of the Subcommittee on the Constitution and Civil Justice, for his opening statement.
Thank you, Mr. Chairman. I appreciate being recognized, and I appreciate Mr. Sensenbrenner and you and others working to bring the Kelo decision forward. I wanted to recap some of my memories with regard to the Kelo decision. And when that decision came down, it was shocking to us who read the Constitution. Nor shall private property be taken for public use without just compensation. Very, very clear. Our founding fathers had great reverence for property, life, liberty, and property, and yet the effect of that decision was, as Chairman Goodlatte said, to strike 3 words from the Fifth Amendment for public use. And I was livid at that decision of the Supreme Court. I couldn't think it could be more starkly wrong. When the court comes down with a decision that doesn't match up to what the Constitution says, then we look at that and we think, well, how are we going to amend the Constitution to fix this one? And the only words we could come up with were, and we really mean it this time, put those 3 words back in. Of course, we know that's not any more effective than the original words that were there. So we brought a resolution within 7 days. We brought a resolution of disapproval to the floor of the House of Representatives, and in that, and I had not yet read Justice O'Connor's dissent. But when I went to the floor, I found out that later on that my words matched hers. And I was sitting in the front row waiting for the former member of this committee, Barney Frank, to finish his statements, planning on rebutting Mr. Frank. What I found out was he agreed with me. It all flowed out the same way, that for public use is an important clause within the Fifth Amendment, and it needs to be restored within the Fifth Amendment. So Justice O'Connor, Barney Frank, Steve King, and a whole list of others agreed that the Fifth Amendment means what it says. I brought also an amendment to the appropriations bill to strike, as my memory tells me, $1.5 million from the administrative budget of the Supreme Court, which was the nominal amount of the property that was confiscated in New London. And of course, that was amazingly didn't pass off the floor of the House at that time. But it sent a message to the court, and the court was completely out of bounds. I hosted a breakfast with Justice Scalia some months after that, and this is the part that I wanted to make sure goes into the record. He said he expected the erroneous, that's my word, erroneous, I'll just put it this way. He expected the Kelo decision at some point to be reversed by the court. I look forward to that day, and we're doing what we can do this day to restore as many property rights as we can legislatively. So I applaud the authors of this legislation, urge its adoption, yield back the balance of my time.
Chair, thanks, gentlemen. Are there any amendments to?
Chairman,
What purpose the gentleman from New York seek?
an amendment at the desk.
Clerk will report the amendment.
Amendment to H.R. 1689 offered by Mr. Nadler of New York. Page 1, line 8, strike in general. Page 2, strike
Without
line.
objection, the amendment is considered as read, and the gentleman is recognized for 5 minutes on his amendment.
Thank you, Mr. Chairman. Mr. Chairman, my amendment is very straightforward, and I hope the members, regardless of their views on the underlying bill, will consider its merits. The amendment would strike the bill's draconian penalty and replace it with one that would enable aggrieved parties to go to court before a taking occurs to try to stop it, rather than waiting until after it is too late, when the only remedy under this bill is to cause their community financial ruin. The bill as proposed imposes a substantial penalty on any jurisdiction that is found to have used the power of eminent domain for a prohibited purpose, or that has put the condemned property to a prohibited use at a later time. The penalty is the loss of all economic development funding for a 2-year period. As the bill does not specify what the term economic development funding means, we can only guess. We can assume that if it includes most of the programs we normally associate with economic development, the loss of that funding or the requirement that it be repaid to the federal government would be financially devastating to the jurisdiction hit by the penalty. Given the tight budget states and localities face, it would probably bankrupt most of them. But the problem does not end there. In view of the threat of the bill's penalty, and in view of the uncertainty of what a subsequent mayor and governor might do, it is inescapable that no jurisdiction could ever float another bond again. No prudent bond underwriter would ever take the chance that over the life of a bond, over the 25 or 30-year life of the bond, a future administration might make a mistake and compromise its ability to repay the note by giving up the federal aid for 2 years by an improper taking at some future time. Even if the jurisdiction does nothing wrong, even if it never uses eminent domain at all, it will be paralyzed financially by the penalty in this bill, because the fear that it might at some point in the future use eminent domain improperly and might therefore lose all federal aid would inhibit its ability to sell bonds. And it makes no sense, because the bill does not even help aggrieved property owners, since it does not let them go to court until the condemnation has been completed. At that point, they have lost their property, and they have received whatever compensation they are entitled to under the law. The bill does not give them the opportunity to stop the condemnation. It does not give them the ability to get a court to have their property returned. It does not give them any damages. The only thing they can get is the perverse satisfaction of bankrupting their community. My amendment takes another approach, which I think achieves the goals of the bill without destroying the finances of every state and local government in the country. The amendment allows the property owner or his tenant or the Attorney General to go to court not after the condemnation, but when it begins. The property owner would be able to seek equitable relief, including an injunction against the taking, damages if appropriate, and attorney's fees. If the taking is illegal under this bill, it would be stopped, and the property owner would get to keep his property. If he is damaged by the illegal taking, he can get compensation. That is what every homeowner wants. A homeowner wants to keep his property and protect it from illegal takings. That is what my amendment would give him. Now, frankly, some may ask, if I don't like this bill, why am I making it effective? And the answer is because I do not want every locality, whether they ever use eminent domain or not, to have a cloud on their future federal aid that will inhibit them from floating bonds. So, to prevent the cloud on the future federal aid that would limit or eliminate the ability of local governments to float bonds, and to give property owners faced with an improper taking the ability to stop that taking, rather than to sit around, cry after it, and do nothing to get compensation or get equitable relief to stop it, but only to ruin their community, I move this amendment. I yield back the balance of my time.
Mr. Chairman,
What purpose is the gentleman from Wisconsin?
I rise in opposition to the amendment.
Gentleman's recognized for 5 minutes.
Mr. Chairman, this amendment guts the bill. There's no two ways about that. And it seems to me that in order to make the bill effective, there's got to be a stick involved with the carrot. And the stick is very simple, and that is if you break the law, you're going to have to pay for it. And the paying for this is not getting economic development funds for 2 years. Now, in many cases, the economic development funds are used to help finance the taking. So, where are we at? If you don't have that kind of a penalty, you're going to see communities that want to take people's property because they can get more tax revenue out of putting a shopping mall or a Four Seasons hotel up instead of the old house or houses that are there, going ahead and trying to do that as well as a way of relieving their budget problems. So the amendment is really a canard. Now let me talk about the type of relief that's available in the bill without the amendment of the gentleman from New York. They're comprehensive. They include all manner of relief from preliminary injunctions and temporary restraining orders, the award of attorney's fees, and the ability of the state or locality to return or replace the property to avoid the penalties under this bill. That is key. Without Mr. Nadler's amendment, if the municipality has broken the law and has taken a piece of private property for some nebulous economic development reason, they can get out of losing their federal economic development funds for the next 2 years simply by offering to return or replace the money or the property. So, really, what's the beef? Mr. Nadler's complaint about bond counsel being very squeamish about authorizing or signing off on bond issues, in my opinion, is a canard. The thing is there are all kinds of laws on the books, and maybe there will be a penalty involved, and bonds cannot be marketed if they break another part of the law that doesn't deal with this. So I think we have to assume that the states and localities will be law-abiding. They will follow this law as they have to follow all of the other laws relative to the flotation of bonds or other types of debts. And we even give the states or localities some wiggle room to get out of this simply by offering to return or replace the property. I believe that this amendment should be overwhelmingly rejected. I urge a no vote and yield back the balance of my time.
First, the gentleman from Maryland seek recognition.
Move to strike the last word. I want to speak in favor of the amendment.
The gentleman is recognized for 5 minutes.
Mr. Chairman, thank you very much. I rise in support of the amendment, not just because it makes the underlying intent of the bill effective, as Mr. Nadler says, but because it makes the bill constitutional. Otherwise, without it, I think the way the bill is written is unconstitutional. Everybody here knows about the Supreme Court's decision in NFIB versus Sebelius in 2012, which struck down the provision in the Affordable Care Act, in Obamacare, which said that if you, the state, don't go along with the Medicaid expansion, we're going to cut off all Medicaid funds to you. And the Supreme Court said that that was a coercive and abusive use of the spending power. It must be much more closely targeted so that it could only really be said, if you don't expand, you won't get the money that we're giving to the states that are in fact expanding. But look at what the bill does as I read it, and please correct me if I'm wrong, Mr. Chair. Take the state of the Commonwealth of Virginia, if the city of Alexandria, for example, engages in a use of the eminent domain power, which is declared to run afoul of the provision in this bill, which says you can't use it for economic development, at that point, no city or county in Virginia or the state itself could receive any economic development funding from the U.S. government. That's Richmond and Charlottesville and Roanoke. Everybody's cut off. At least that's the way that I'm reading it. And if that's not right, I hope we can clarify that. I think that that's clearly unconstitutional under the Supreme Court's authority on what's proper use of our spending power discretion. But let me just also
yield.
Please.
Okay. I believe the court in Sebelius made it clear that Congress may attach appropriate conditions to federal taxing and spending programs to preserve its control over the use of federal funds. That's...
You're just stating a truism there, but what about my point?
No, I'm stating what the Supreme Court said in the case that you cited. And that's 132 Supreme Court,
let me reclaim my time.
2566 at 2603, 1912.
Let me reclaim my time, if I could. What the Supreme Court said in striking down that provision was the Congress could not punish the state for not participating in that particular expansion of the Medicaid program by taking away all Medicaid funding. And that's exactly the design of this bill here, which is if you engage in what we view as an improper, not even an unconstitutional, but an improper use of eminent domain in one of your subdivisions, we will cut off all economic development funding to you in all of the programs. And please correct me on that specific point if you can. I'm happy to yield. Okay, thank you. So, by all means.
I think the gentleman is entirely correct, because clearly Congress can condition Medicaid funds on certain things connected with the use of the Medicaid funds. What the court found was that a draconian punishment of cutoff of all Medicaid funds was coercion of the state. And here what you're talking about is all economic development funds, whether connected with that taking or not, whether connected in any logical way with the taking or not. It's clearly punitive. The bill makes it punitive, and it's clearly coercive, and it falls squarely afoul of the Sebelius decision. In fact, I would say it's far more coercive and more unconstitutional, if you can say that, than the case in the Sebelius decision.
Will the gentleman yield to a question?
By all means.
As I think about the gentleman's argument, isn't this actually even more egregious? Because at least in the Sebelius case, there was a decision by the state that was attempted to be punished. In this example, there will be counties that did not make a decision that was inconsistent with the legislative intent of the statute that will be punished. I mean, there seems to be due process arguments even.
Well, yes, reclaiming my time. I mean, that's the point I'm trying to make about Richmond and Charlottesville and Roanoke. You're essentially punishing the entire state for what one city or town has done in running afoul of congressional intent.
Would the gentleman yield?
Yes, by all means.
Just a question. I'm looking at page 2, line 8. A violation of subsection A by a state or political subdivision shall render such state or political subdivision. I think it's pretty clear there that we're talking about not an entire state. So in your example, if Alexandria did something, Charlottesville's not going to be affected.
Well, let's see, except that if you look at the beginning of it, no state or political subdivision shall exercise its power of domain or allow the exercise of such power by any person or entity, et cetera. All, as you know, under Dillon's rule, all power in the local governments is derivative of state power. So any power that Charlottesville or Richmond has, or Alexandria or Arlington, comes from the state. The state would be allowing it to exercise its eminent domain power in a way that's antithetical to congressional purpose. So I think, unless we clarify it, all of the public funds would have to be revoked at that point. Mr. Chair, if I could just reclaim my time.
The time of the gentleman has expired. The chair recognizes himself in opposition to the amendment in defense of the Commonwealth of Virginia and its subdivisions, and yields to the gentleman from Wisconsin.
Well, I thank the gentleman for yielding. Again, with all due respect, I think the gentleman from Maryland has erroneously interpreted the law. The Sebelius case, also said that the federal government could not kill all Medicaid funds because Medicaid funds frequently exceed 20% of the total state budget. Now, South Dakota ended up suing the federal government over withholding 5% of highway funds for states that did not raise the drinking age to 21. That was upheld. Now, there's no way that taking away economic development funds for a jurisdiction that has been found by a court to violate this proposed law will even come close to the 5% that was okayed in South Dakota v. Dole. So, with all due respect, Chicken Little is wrong on this one. The sky is not falling because of the small amount of funds for economic development that will be denied for 2 years to a jurisdiction that has been found by a court to violate the law that is being proposed here.
Will the gentleman yield?
The time belongs to the chairman.
I'm happy to yield.
Thank you, Mr. Chairman. Just 2 points on that. One is, does everyone then agree that the punishment, the financial punishment, should not apply to other subdivisions of the state? It should apply only to the subdivision which runs afoul of congressional purpose? Is that the intent? That would be my first question. The second is, I'm not quite sure what the 5%...
Reclaiming my time, the answer to that is yes, we only intend the subdivision that violates the law to receive that penalty. Okay,
and so, but I'm not quite sure what the 5% and 20% from those two disparate contexts refers to. One, I recall, is about highway funding in states that don't adjust the drinking age.
Just saying that there are many subdivisions in the Commonwealth of Virginia, the example that you cited, and that the economic development funds from the federal government to any one of them would be a tiny percentage of the
Well,
amount paid to the state of Virginia.
but the constitutionally relevant point is what percentage of the funding is cut off, and here it would be 100% of economic development funding that would be
To
nullified.
the community that had violated law and a court had found them to have violated the law. Very different than the Sebelius case in which the Supreme Court noted that the states had agreed to and were participating in the existing Medicaid program, and the federal government saying they would cut off all of those funds for not expanding the program is a very different dynamic than breaking the law and saying you're going to lose the funds if you break the law.
Would the gentleman yield?
I will yield.
It's not different at all, because you're breaking the law by engaging in a taking, and maybe you thought you weren't breaking it, but you know the question is how economic the taking was. But the punishment is not funding related to that taking. The punishment is all economic development funds. It's precisely congruent with the Sebelius case. I yield back.
The question occurs on the amendment offered by the gentleman from New York. All those in favor respond by saying aye.
Aye.
Those opposed, no. No. To the chair, the noes have it. The amendment is not agreed to. Are there further amendments to H.R. 1689? A reporting quorum being present, the question is on the motion to report the bill H.R. 1689 as amended favorably to the House. Those in favor respond by saying aye. Those opposed, no.
No.
In the chair, the ayes have it, and the bill is ordered reported favorably. The members will have 2 days to submit views. And before we adjourn, I would like to take a moment to welcome back to the committee a returning veteran of the committee, and that is Representative Keith Rothfuss. He previously served on the committee in the 113th Congress, and we are very thrilled to have him rejoin us as the representative of Pennsylvania's 12th district. His experience in the private sector, helping small businesses expand and create jobs for Americans, will be invaluable once again to the committee. So please join me in welcoming him back. Does the gentleman from New York seek to say anything on this subject?
Yes, I join the chairman in welcoming the gentleman from Pennsylvania back to the committee. Some good sense from Pennsylvania is always to be desired.
I thank the gentleman. I thank the gentleman from Pennsylvania. This concludes our business for today. Thanks to all the members for attending, and the markup is adjourned.